Welcome everybody to our terrific luncheon panel on Dobbs and the rule of law. I'm Lee Lipperman-Otis, the Senior Vice President of the Federalist Society and Director of the Faculty Division, and I'm thrilled to welcome you to what I'm sure will be a terrific discussion. And without further ado, I will turn things over to our moderator, Professor Stephen Sachs, who holds, I cannot resist saying this, the Antonin Scalia Chair at Harvard Law School.
Thank you very much. Good afternoon to all of you. It's my honor today to introduce our panel on the Dobbs decision and the rule of law. Dobbs versus Jackson Women's Health Organization has been described as one of the most important constitutional decisions, if not the most important, of the last several decades. The Supreme Court, by a 6-3 vote, upheld a Mississippi ban on abortions after the 15th week of pregnancy, and by a 5-4 vote, it overruled Roe v. Wade and Planned Parenthood v. Casey and held that the 14th Amendment does not protect a right to abortion. Some who criticized Roe and Casey have seen Dobbs as a long-awaited correction for judicial usurpation, abandoning a right to abortion ungrounded in constitutional text or historical practice. But some who criticize Dobbs have seen in the court's decision an indifference to long-standing precedent, to fundamental freedoms, or even to the rule of law. Dobbs was, of course, an epochal change in the judicial treatment of abortion law, but it's also more than that. The majority, concurring, and dissenting opinions express fundamentally different visions of the role of the court in American law. They express fundamentally different visions of its fundamental rights jurisprudence. And they express fundamentally different visions, perhaps, of the process of constitutional interpretation writ large. So Dobbs raises very important questions for the future of constitutional law. Which of these visions, if any, will come to fruition? Will Dobbs turn out to be more like U.S. v. Lopez, a case once expected to herald a federalism revolution, but that essentially left the prior Wickard regime intact? Or will Dobbs turn out to be more like West Coast Hotel, a case that overruled not just Lochner, but an entire way of looking at the law and established a thoroughgoing rejection of the jurisprudence of the Lochner court? And perhaps more appropriately for us academics than these crystal ball predictions, which of these visions, if any, is actually right? Which is the most true to our own Constitution and laws? In answering these questions, we are joined today by 4 eminent panelists. We will start with opening remarks from each, and then a round of responses. I'll then ask them some questions to start a conversation across the panel. For those of you who have questions of your own, at roughly 2 o'clock or so, I'll invite you to line up at the microphone, and at that time we'll take questions from the audience. Contrary to our prior advertising, unfortunately, we do not have as our first panelist Jennifer Mascott, Assistant Professor of Law at Antonin Scalia Law School, who couldn't join us due to a last-minute family conflict. But she is, however, ably replaced by Joelle Elisea, Assistant Professor of Law at Catholic University's Columbus School of Law and co-director of the school's project on constitutional originalism and the Catholic intellectual tradition. We are also fortunate to have with us my colleague Vicki Jackson, the Laurence H. Tribe Professor of Constitutional Law at Harvard Law School, Sherif Girgis, Associate Professor of Law at Notre Dame Law School, and Riva Siegel, the Nicholas Katzenbach Professor of Law at Yale Law School. Rather than attempt to summarize even briefly the various writings and accomplishments of our panelists, I will let their erudition speak for itself. Please join me in welcoming them.
Well, thank you, Steve, and it's a pleasure to be on such a distinguished panel. I'm honored to be part of this panel. I'm going to be focusing on the question of the legitimacy of the Dobbs decision, which has been a major topic of controversy since it was issued, specifically thinking about legitimacy in the way that Richard Fallon suggests: sociological legitimacy, legal legitimacy, and moral legitimacy. So sociological legitimacy being how do the people perceive an opinion and whether it is worthy of obedience, legal legitimacy being whether that opinion accords with the relevant legal materials, and moral legitimacy whether an opinion is morally justifiable. I'm going to only touch briefly on legal and sociological legitimacy. I'll focus mostly on moral legitimacy, and I'll assume that Dobbs is an originalist decision as part of my analysis, even though I know that's controversial. The reason I'm doing that is because I interpret the dissent in Dobbs to have assumed that the Glucksberg test is originalist-like, and to be attacking originalism as part of its moral critique, and that's what I'm going to be addressing. So starting with the sociological legitimacy angle, a lot of critics of the decision have argued that because Dobbs is controversial and opposed by a significant portion of the American population, it forfeits, or at least risks forfeiting, the court's sociological legitimacy. I think that there are two problems with that argument. The first being that it ignores the fact that Roe itself is deeply controversial and opposed by a significant portion of the American population, so much so that it caused a realignment in American politics. The second being that it assumes that the court, implicitly assumes that the court should be taking into account public perception in deciding how to decide a case like Dobbs. And importantly, both the majority and the dissent in Dobbs reject that proposition. The dissent interprets the language from Casey about political pressure not as saying that you should take into account political pressure, but as instead underscoring the need to decide controversial cases in accordance with law and not according to sociological considerations. So both majority and the dissent in Dobbs reject the notion that we should take into account how the opinion will be received in deciding what the right outcome of the case should be. Instead, they rest sociological legitimacy on legal legitimacy, and so that leads right into a discussion of that, legal legitimacy. And there, I think the most interesting fact of the joint dissent is that it does not dispute that if Glucksberg, a history-centered approach, is the right approach to identifying unenumerated rights, then Roe v. Wade is wrongly decided. The joint dissent does not dispute that. In fact, it affirmatively concedes that in 1868 there was no nationwide right to end a pregnancy and no thought that the 14th Amendment provided one. That's from the joint dissent. So really the debate between the dissent and the majority on this score at least is whether the Glucksberg test is the right test. And there, the critique of the Glucksberg test and of originalism more broadly, which the dissent sees as part of its critique of Glucksberg, comes down to a moral critique. The best argument that the dissent makes against originalism is a moral one, and that is that originalism is just morally unsupportable. And the dissent makes two versions of that argument, or I should say two different kinds of arguments about why originalism is morally unsupportable. What it calls an argument from constitutional substance and another an argument from constitutional method. On constitutional substance, the argument that the dissent makes is because originalism requires honoring the moral decisions of those in the past, and because the joint dissent disagrees with the substance of those moral decisions, originalism, if applied, requires keeping in place in the Constitution substantive moral flaws. For example, the dissent says, because laws in 1868 deprived women of any control over their bodies, the majority approves states doing so today, unquote. So that concern there is that originalism leads to substantively incorrect outcomes that are preserved through originalism being the methodology that we adopt. I'll say two things about that. One is that that critique implicitly rests, or I should say explicitly rests, on a particular view of abortion and the morality of abortion. So somebody who's pro-life like I am would not view the lack of a right to abortion in the Constitution as a moral failing of the Constitution, indeed quite the opposite. But let's just bracket that debate for now instead of getting into the merits of the abortion issue. I want to instead focus on the other assumption of that critique, which is that our method of constitutional adjudication should conform to what we believe are the correct moral outcomes in concrete cases. So if our method of constitutional adjudication would lead to outcomes that we regard as immoral, we should change our method to ensure that we reach correct moral outcomes. That's a very common view among constitutional theorists, but I think it's mistaken. And I think it's mistaken because it overlooks the moral significance of authority and the profound moral harm of undercutting legitimate authority. So let me just unpack that very briefly. There are all sorts of things that we find desirable because they're good for us, things like health, things like friendship, and we have a moral obligation to pursue things that are good for us, things that make us more truly ourselves as human beings. And most of if not all of those things, are things that we have to pursue in community with other people, things like friendship, for example. But in pursuing things with other people, you get all sorts of social coordination problems. And so in order to allow us to achieve those good things, we need somebody to come in and resolve those social coordination problems, and that's the role of authority. Somebody just has to decide what side of the road we're going to drive on so that we don't run into each other and destroy the good of our health, for example. So the moral justification for authority is that it secures the conditions that allow us to achieve the goods in society that we're morally obligated to be pursuing for our own good. And that means that we have an obligation to obey legitimate authority and preserve it as an essential means for achieving our own good. So if the 14th Amendment's ratifiers are legitimate authority, and if, as the dissent concedes, they did not place a right to abortion in the Constitution in 1868, then to impose a right to abortion by judicial fiat in 1973 is to subvert the legitimate authority of those ratifiers and to do profound harm to the common good. And that's why the moral consideration of just a few cases in isolation overlooks significant moral harms that are done by this kind of results-oriented approach to jurisprudence. But, of course, what I just said assumes that the 14th Amendment's ratifiers are the legitimate authority, and that's where the second argument that the dissent makes comes in, the argument from constitutional method that the dissent makes. There, the dissent's argument is that because originalism is wrong because it requires treating as authoritative decisions rendered under circumstances of unjust exclusion, specifically in the case of the 14th Amendment and in Dobbs, the exclusion of women from the 14th Amendment ratification process. So what the dissent is arguing is that there's an inherent moral harm here to having excluded women from the 14th Amendment ratification process, and that originalism carries forward that moral harm and perpetuates the injustice by causing us to treat the decisions of 1868 as authoritative. Now, that's a much more sweeping argument than the first one I articulated from the dissent, the constitutional substance argument, because this is an argument that says it's not just that originalism leads to bad outcomes, it's that originalism requires treating as authoritative decisions made by an illegitimate authority, the ratifiers in 1868. That raises the question, well, then who is the legitimate authority, if it's not the ratifiers of the 14th Amendment? And the dissent never squarely addresses that question, but does give a few hints. And either way, either it being the court itself being the legitimate authority or us living today being the legitimate authority, the effect of the dissent's argument is to say that we today, those of us living today, are engaged in a continuous issuance of the 14th Amendment as we being the legitimate authority, as opposed to thinking of the 14th Amendment as being issued at a discrete moment in time by the ratifiers as the legitimate authority. The problem with that is that it's fundamentally incompatible with the nature of American constitutionalism, because our Constitution does establish a division between higher and ordinary lawmaking. The Constitution declares itself a form of fundamental higher law above ordinary law, and it separates out deliberately the lawmaking process for higher lawmaking through Article 5. And it does that to preserve the higher lawmaking status of the Constitution. But if the dissent's view is right, and if we today are the legitimate authority continually issuing the 14th Amendment through ordinary politics, through changes in ordinary politics, elections, judicial appointments, things like that, then you've collapsed the distinction between higher and ordinary lawmaking. And so the effect is to say that even though the ratifiers, the legitimate authority of 1868, did not place a right to abortion in the Constitution, we today can do so through judicial imposition, like in Roe versus Wade. That means, just to underscore this, that the argument there is that American constitutionalism in separating higher from ordinary lawmaking is immoral. And that's a revolutionary kind of argument. And it's an argument that some progressive constitutional theorists are willing to embrace. So Sam Moyn, Ryan Dorfler have made this kind of argument, right, that we should just do away with the distinction between higher and ordinary lawmaking and American constitutionalism because it's immoral. But that is calling for a revolution. That's not just an argument against originalism. And because a revolution and an overthrowing of a constitutional system has all sorts of terrible moral consequences, the burden of justification is therefore much higher, and I see no way in which the critics of Dobbs can carry that burden, quite apart from their critique of originalism, their critique of American constitutionalism. And so, just to quickly conclude, even though the moral critique of Dobbs, I think, is the strongest critique that's offered by the dissent, it doesn't grapple with significant counter-arguments and countervailing moral considerations. And when you take those into account, and others that I haven't mentioned here, I think it's clear that Dobbs is not only the best, the most important legal decision since Brown versus Board of Education, but the most important moral decision as well. Thank you.
Thank you. Professor Jackson.
Is it okay if I speak standing up?
Of course.
Okay, so just give me a moment so I don't trip. Well, thank you so much for inviting me. I'm sure most of you will disagree with my remarks, but I look forward to your reactions and to learning from your comments. The major thrust of my talk is that narrow forms of historical, moment-based interpretation of our difficult-to-amend Constitution as the exclusive or predominant source are inconsistent with the very purposes of a Constitution. That'll be my first point. My second point is more speculative, but it is that Dobbs may very well generate the kind of backlash that occurred in Ireland in the late 20th and first part of this century, resulting in a disavowal of its basic premises. Now, a caveat on vocabulary. I understand there is a debate about whether Dobbs should be viewed as an originalist opinion as such, or rather as an instantiation of the Glucksberg approach, which I see as a narrowly historical approach to defining substantive liberties, finding whether they are deeply rooted in history by reference to laws that existed at a point in the past. In this talk, I will use the words originalism or originalist to embrace both of these as they seek to constrain judicial discretion by focusing attention exclusively or primarily on very specific past laws and acts. Now, if time permits, I have a brief word to say about the rule of law, and in Q&A, if there's any interest, I'd be happy to talk about the possibilities that one could have constitutional respect and protection for pregnant women's rights to terminate, even if at the same time there is constitutional recognition of unborn or fetal life as a subject of protection. That's a comparative piece, only if you're interested. All right, point one. Why do I say that interpretive approaches that focus primarily and narrowly on past decisions are inconsistent conceptually and instrumentally with the nature and purpose of a constitution? All right, I think conceptually there are three problems with that approach. First, a constitution, unlike an ordinary statute, is designed as an organic instrument to last over time and across generations. It gains meaning and legitimacy through the acts and understandings of different generations, as Justice Holmes indicated in a famous passage in Missouri against Holland. Moreover, as Professor Nick Barber, who's in Britain, has argued, a constitution as a conceptual matter has the overarching purpose of advancing the welfare of the people. That's point one. Point two. Oh no, actually, I have a little bit more to say about this. If the people in each generation can't view themselves and their understandings as reflected in and protected by the Constitution, that Constitution will lose legitimacy, and as it does so, it will lose the power to bind. In a very difficult to amend Constitution like ours, this process of intergenerational respect and engagement occurs in part through constitutional adjudication, as the Dobbs dissenters meant when they said the Constitution's meaning gains content from the long sweep of history and from successive judicial precedents, each looking to the last, they wrote, and each seeking to apply the Constitution's most fundamental commitments to new conditions. Now, this is not an unbounded living Constitution that can float anywhere in the sky. Rather, I think it calls to mind the Canadian metaphor that a Constitution is a living tree. It has roots, and those roots are, in the United States, the text. We have a written text. But the Canadians developed this in a case in the 1929 where there was an originalist argument that a woman could not be appointed as a senator because in 1867, when the Constitution was passed, the word person meant men. And the Privy Council said, no, 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 no. Constitutions are organic acts, and we have to interpret them in ways that can evolve. All right, my second argument conceptually about constitutions is that the purpose of a writing, of an initial constitution, and particularly of amendments, the purpose is to change the fundamental norm. And interpretive approaches that measure the meaning of an amendment based on what statutory laws existed at the time are inconsistent with that purpose of a constitutional amendment. The court's reliance on the state of law at the time of the 14th Amendment's enacted, a body of law made largely, as was noted, without the participation of women, who nonetheless are persons and citizens within the meaning of those terms, that reliance would strip the valuable protections of Section 1 of their constitutional function of changing the basic law and establishing new standards of constitutional protection. Third point, smaller level point, as David Strauss has argued, constitutions that endure, that fulfill this connecting the generations purpose, do so by combining specificity on matters where specificity really helps, like how often do you have to have elections? That's something that's really good, comparative and historical study tells us to have written down. What are the initial starting out institutions of government? You need to have that. On the one hand, and Strauss says you need to be general about other subjects where generality is going to help the Constitution do its work. Principles, general principles to maintain respect and connection to the people need to be interpreted in ways that can make sense to those who are governed by them. That doesn't mean only what today's generation thinks matters, but neither does it mean that we only look to one particular moment in time. Instrumentally, now there's an instrumental reason why I object to originalism, and that comes from my agreement with Professor Fallon in a piece he wrote called How to Choose a Constitutional Theory, in which he suggested that adopting an interpretive theory should be driven in part by instrumental concerns of whether the results of that theory over a range of issues, not case by case, but over a range of issues will enable constitutional law to promote what he called the rule of law, political democracy, and appropriately specified substantive rights. A shorthand might be to say that instrumental concerns are for bringing constitutional law closer to some shared conception of good governance and rights protection. Originalist methods that focus only on law and social understandings in 1789 or 1791 or 1868 are privileging perspectives held by what was then a small minority of the population. That alone is reason to doubt the exclusivity of using those materials in interpretation. In Dobbs, the court's failure to recognize as a very fundamental part of a pregnant woman's liberty the freedom from physical encroachment on the body caused by pregnancy, and even encroachment on freedom of movement, as some who have been pregnant will have experienced. Its treatment of the termination decision as an ordinary liberty, subject to any arguably rational regulation, is remarkably indifferent to pregnant women's health and well-being and to their interest in avoiding what scholars have called a totalitarian takeover by the government of a person's life. All right, that's why I think the method is inconsistent with what I see as the purposes of a constitution. Second point, why Dobbs may contribute to the death of originalism. People look at me askance when I say this, but I'm going to give you two reasons. First, I think Dobbs reveals the failure of originalism's promise of constraint. And second, I think the consequences of Dobbs may generate a kind of ideological backlash in the years to come. Let me explain. On constraint, the originalist methods deployed by the court, as Professor Fallon has pointed out in a new paper, which he's giving here tomorrow at the ALS, they've applied originalism in a very selective way in dealing with stare decisis, What part of the past are we going to keep? What part are we going to throw away? Originalism actually doesn't provide an answer to that. By virtue of the selectivity with which originalist methods are deployed in constitutional law, that sense of constraint is lost. One example is at the founding and throughout the 19th century, well beyond the time of the 14th Amendment and into the early 20th century, many existing laws prohibited speech that today's understanding of the First Amendment would protect. All right, so the Sedition Acts are enacted by Congress soon after the First Amendment. They're not put finally to rest until New York Times and Sullivan in the 1960s. There were laws prohibiting blasphemy or speech inconsistent with public morals. The Supreme Court in 1952 is the time when I could find the court saying, actually, you can't punish blasphemy. That's pretty late on. Now, on Dobbs's reasoning, the meaning of free speech maybe shouldn't extend to protecting that kind of speech, but I don't think Dobbs's methodology is going to be applied consistently across those areas. The second reason originalism is not constraining, as I think Dobbs illustrates, is because history rarely yields clear answers. As many critics have noted, collective decision-making is rarely univocal in its understandings, and accurate legal history is really hard to do well. There's a forthcoming paper in Stanford Law Review by someone I don't know named Aaron Tang, who argues that the court erred very substantially in its count of the cases of the states, count of the states who in 1868 prohibited all abortions. He writes, as many as 21 states out of the 37 in the Union when the 14th Amendment was adopted, not the 9, Dobbs suggests, permitted pre-quickening abortion. Now, his examples are debatable, but his example from Alabama really gave me pause because the court reprinted in its appendix a statute enacted in Alabama in the 1840s that sounded like it prohibited all abortions on pregnant women. And in the 1850s, he writes, the Alabama Supreme Court concluded that in that state it was only prohibited to have abortions were only prohibited after quickening. The common law background, when you read a statute against the background that the common law is not likely to be derogated from, that's what seemed to have been going on there and possibly in other cases. I've already talked to you about do I have time to do my backlash point? Maybe not. I'll save my backlash point because our chair just gave me the signal. What I want to say is I think the major error of Dobbs was its rejection of a fundamental interest on the part of the pregnant woman in having some decisional agency and the adoption of a rational basis standard. Happy to elaborate later. Thank you.
Thank you.
Thank you. So I'm very, very honored to be here, partly because of everybody on this panel who I've been reading for many years to a person, including the one who's a lot younger than me, and also especially because of Professor Siegel. I owe a ton to her. I've been learning a lot from her. I learned anti-discrimination law in law school from her. She's thinking not enough. And also, I think I also learned something about the role morality of being a law professor. She's someone who's fully gripped by the moral importance of the issues she's writing on, and also equally fully committed to intellectual integrity and honesty. She's read conservative literature better than I have on these issues, and also equally committed to being a kind of loyal advocate of students who write on the same issues from a very different perspective. So I'm very grateful for that. I hope I haven't gotten you canceled back at home. There's a lot of ways into these issues. There's methodological ones, there's methodological and substantive ones. I have some thoughts on each of those, but I'm going to focus on one kind of narrow legitimacy point and then on one broader sort of substantive point. The first one, legitimacy. So I think if you read the dissent, there's lots of different points made, but one that stuck out at me as especially motivating for the dissent was expressed in a sentence that goes something like, the only reason that Roe and Casey are being overturned today is that the majority has always despised them and now has the votes to discard them. And that's obviously hearkening to the point that Justice Kagan then made in several talks on the lecture circuit, which I think can be fairly summed up as it's really bad for the rule of law and for the social and sociological legitimacy of the court if a change in personnel leads to a huge change in law. And my thought in response to that is, it depends. The main mechanism that the Constitution provides for the people to give effect to their understanding of what a legitimate court looks like is to elect the politicians who select the judges. So if the major change in law is due to a change in personnel that in turn is due in part to a social and political movement that was premised on the idea that Roe is illegitimate, not constitutional law, as John Hart Ely said, then there's a serious argument to be made that actually Dobbs is the legitimacy process working. In fact, it's very hard for me to think of another example of a case where you can say that the prevalence of a view about a matter of legal interpretation was a but-for cause of a president winning an election. More than you can say that in this case. Now, obviously, there are a bunch of other aspects of the process that got from 2016 to Dobbs that people can say, well, actually cuts the other way, it undermines legitimacy, and we can talk about that. But just the narrow point I'm making is that the flip and personnel point can cut both ways. The second and more extensive point I want to make is on the equal protection argument. So it's not quite made in the dissent, but it is obviously animating the dissent from top to bottom. There's lots of language and appeals to equality and the way that protecting access to abortion is required for women's political and economic and social equality. And the majority opinion in terms of, so one aspect of rule of law is how well have they explained themselves. I think their explanation of their rejection of the equal protection argument is the quickest and least satisfying. And that may be because the dissent didn't make it full bore, maybe because the parties didn't make it. An amicus brief by Professor Siegel made it, and they're responding to that, among other things. But on reflection, I have come to think that the bulk of the Dobbs analysis, which is about whether there's a deeply rooted history and tradition to support the kind of holding in Roe, actually answers the equal protection argument as well, or at least many forms of it. And that's because I think that the equal protection argument, at the end of the day, may rise or fall with the weakest premise in Roe, which Dobbs talked at great length about. So this is a big claim, and I'm only going to make a kind of schematic argument for it, or give you a sense of why I think that may be the case, and we can talk about details afterward. So the part of Roe that was mostly invested, when we think of John Hart Ely and Larry Tribe and others critiquing it, it's easy to have a general vague impression that they just thought the reasoning was bad. But if you look carefully, the thing they most critiqued was not the general idea that the Constitution or something in the Constitution or privacy interests or something like that give women an interest of constitutional significance in getting an abortion. It was the second part of Roe, which said that the interest in fetal life doesn't outweigh it. That somehow the Constitution itself takes a position on this kind of abstruse question of moral philosophy about fetal moral worth, and in particular takes the position that the fetus doesn't count for enough until viability to justify overriding the interest in getting an abortion. That's the thing that John Hart Ely said, the court is mistaking a definition for a syllogism because it says viability matters because that's when the fetus is viable, and that's the thing that that Larry Tribe was talking about when he wrote in his foreword. It was something like, one has to reread the opinion several times to be sure that nothing has been inadvertently left out by way of explanation. And I think the general reason for that is clear enough. The text doesn't make that point. The history, there's nowhere in history where you could say that our law or social practices or something took a position on that question. And I've views about the Professor Tang's arguments on quickening and so on that we can get to in the Q&A. And so where did this come from? The equal protection argument, as I understand it, is supposed to improve on the Roe due process argument by saying, we don't need to make critical judgments about what states can think about fetal moral worth, because quite apart from that, there's a problem with abortion regulations with respect to their impact on women or the motivations that drive them with respect to women. So one version of it goes, look, the pro-life states are accepting a burden on women that they would never accept on men if the tables were turned. And so my question is, does that argument really go through if you grant for argument's sake that the states could see fetal moral worth as equal to a person's worth? For that to be true, if you're spotting the states that premise, then to still show that they're accepting a burden on women they wouldn't accept on men, you have to show that there's some context in which these pro-life states are lifting a burden from men that they wouldn't lift on women at the cost of allowing the intentional taking of innocent human life or something morally comparable. If they aren't doing that, then we haven't yet found an analog. We haven't yet established a sexist double standard. Or if you take the versions of the argument that say, look, these pro-life states, they're not just motivated by a concern for fetal moral worth because they're not doing enough to protect life in other ways, support for health care and so on. And as a policy matter, I think they should be doing all kinds of things that they're not doing. But just the kind of narrow doctrinal point, I think, again, for that to be true, you would have to think that the failure to provide health care support or something like that is morally equivalent to withdrawing the protection of homicide laws from a class of persons. If that's not the case, if those things are different and we're assuming the states can permissibly see fetal life as something like the moral worth of a person, then we haven't yet shown a kind of double standard. The final version of this. So a lot of the arguments go something like this. Abortion regulations are premised on invidious generalizations or stereotypes or norms about women. For example, the expectation that women ought to perform motherhood, which I guess in this sense means at least they ought to bear a child, the fetus, to term. And it seems entirely possible to me and consistent with the literature I've read on these arguments that premise, if it is a premise driving abortion regulations, is the product of two other beliefs, which is that parents have an enforceable duty to accept the ordinary burdens of keeping their kids alive, and that the fetus is a kid. If it's just a product of those two premises and they're both okay constitutionally, then so is the judgment driving the abortion laws, the idea that women ought to bear a child to term. If not, if we want to say, no, one of those is suspect, it's definitely not the idea that parents have a duty to bear the ordinary burdens of keeping their kids alive, so it's got to be the other premise. It's got to be that there's something suspect, there's something impermissible in states thinking that the fetus has moral worth comparable to the worth of a person. And so we're back to that premise. We're just like the due process arguments, I think, at least these versions of the equal protection argument, assume that it's somehow independently constitutionally infirm for states to think that the fetus is anything like the moral worth of a person. And if that's right, then we need then the equal protection argument to go through needs an independent defense of that. But that was the weakest premise of the Roe arguments. That was the premise that Ely and Tribe found so embarrassing. And so I don't think, at the end of the day, the equal protection argument, in the versions I've seen, makes progress on it. And most critically here, the bulk of the Dobbs opinion, which is all about why that premise of Roe was ungrounded, provides a critique of a crucial premise of the equal protection arguments that they didn't give a lot of direct attention to. Thanks.
Okay, I guess I was going to stand up, but I guess I'll stay here. So thanks, Steve, and thanks, everyone, and thank you, Sherif. You're now going to see dialogue. I assume that I was invited here, along with Professor Jackson, to sort of bring inside the room a little bit of the protest from outside the room, and so I'm going to oblige. So I'm going to be speaking to you from a paper that I've got posted on Dobbs. It's up on SSRN, and it's called Memory Games. All right, so I'm going to begin with a thought experiment. So how might you justify taking away rights recently conferred on marginalized groups? Well, why not return the law to an earlier time when those groups had fewer rights? Why might I ask that question? Well, in this paper, I went back to the days of the Reagan administration and was looking at Attorney General Meese's first speeches on originalism. And it's fascinating to see the ways in which the assault on Roe itself really takes root. And I'm just going to read you just fragments of this and then move forward into the Dobbs opinion itself. So when he first begins talking about the jurisprudence of original intention in 1985, in his famous first speech before the ABA, he objected to what he called the, quote, radical egalitarianism and expansive civil libertarianism of the Warren Court. And then, after asking what then should a constitutional jurisprudence actually be, answered, it should be a jurisprudence of original intention. In his second speech in November of '85 at the Federalist Society, Attorney General Meese invoked a jurisprudence of original intention as grounds for attacking Griswold and Roe, and yet remarkably, he offered no particular support for this claim other than a lone quotation from John Hart Ely. That is what appears in the speech as the basis for the objection to Roe and to question its grounds in the Constitution. It's fascinating to see originalism in this era, in the mid-1980s, when there's basically a time before there's a method or historical evidence to support originalism's claims. A young Sam Alito worked on the brief in the Reagan administration that had been filed calling for Roe's overruling in Thornburg in '85. Alito's application for DOJ appointment featured as part of his qualifications his opposition to affirmative action and his interest in seeing Roe overruled. This is all in the 1980s. So nearly 40 years later, Sam Alito got to write that opinion, and he again relied on Ely heavily. But now he offered an historical justification for reversing Roe, not a history of the original understanding, but under a new substantive due process standard. The root impulse was the same as '85, go back in time, as we know, and back under this Glucksberg standard, which I'd love to talk about, and Dobbs, and also Dobbs' history claims, which I'm going to focus on today. I read both of these as a form of living constitutionalism in this paper, which is called Memory Games, Dobbs Originalism as Anti-Democratic Living Constitutionalism. And for the remainder of my remarks, I'm going to really just dig down on the history and traditions account that Justice Alito supplies in the Dobbs opinion and reduce many things one could say about it to one question, which is, do 19th century abortion bans offer a tradition in which we should anchor the Constitution's liberty guarantee? That's my question. Over 8 paragraphs, Justice Alito recounts the arguments of an historian's amicus that the abortion bans were enacted for a mix of legitimate and illegitimate reasons, to protect unborn life, yes, and also to enforce women's family roles and to preserve the ethno-religious character of the nation. Justice Alito rejects this account of mixed motives. I quote him, "Are we to believe that the laws were motivated by hostility to Catholics and women? There's ample evidence that the passage of these laws was instead, his word, instead spurred by a sincere belief that abortion kills a human being." Poof, gone. In place of an encounter with abortion bans as first enacted, in which actors held beliefs about women and beliefs about the fetus, all of which we can assume were sincere, meaning all of it, we instead have a fiction on which the entire Dobbs opinion rests, that people who seek to ban abortion are concerned about the fetus but hold no constitutionally relevant views about women. Women are merely a physical vessel where the fetus is. Justice Alito projects this view throughout Dobbs, and it authorizes the deprivation of women's rights past and present. As I show in my Memory Games article, and really a lot more in my earlier piece, Reasoning from the Body, which I wrote actually a while ago, advocates of 19th century abortion bans enacted abortion bans on caste-based views of women. They argued that women existed to bear and rear children, and that abortion bans were useful in enforcing these sex roles. They mocked women's claims for suffrage and for voluntary motherhood. Contraception was first criminalized in the 1870s. Many statutes, like the Comstock statute passed in 1873, criminalized the distribution of abortifacients and contraceptives together. Wives who under coverture had no rights against rape in marriage now saw their access to contraception and abortion restricted by law. They were subject to compulsory childbearing without a vote or a say in the matter. In short, the statutes in Dobbs' appendix, which are likely miscounted, do read the last section of Aaron Tang's Stanford piece. It really has to do with how you read the word pregnant and other things in these 19th century statutes, have been ripped out of relevant historical context and the story of their genesis utterly whitewashed. In my view, it is terrible history and worse constitutional law for Dobbs to present the statutes in its appendix as the nation's grand history and tradition of liberty. It's shameful to present domination as freedom and to encourage Americans today to view it that way. Women's inequality helped make abortion bans seem reasonable means of protecting unborn life. And it's continuing inequality, the continuing force of these same views about women that makes it possible to talk about the state's interest in protecting embryos and fetuses as if they were disembodied and women had no rights at stake. For Blackstone, the legal existence of women was suspended during marriage and coverture. For moderns, the legal existence of women is suspended during childbearing. A century after the campaign, at the time of Roe, women had the vote but no access to power, in no small part because the society organized motherhood as caste work. A woman who became pregnant would be kicked out of school. A woman who became pregnant would be fired. A woman who became pregnant out of wedlock faced forced marriage or no marriage at all. Forget politics. And if a woman tried to end an unplanned pregnancy, she risked sterility or death, unless the man, a committee of doctors, agreed. Under these conditions, abortion bans could devastate women's lives. Roe responded to women's claims for emancipation, yet could not give a clear or full account of why abortion bans were unconstitutional. The all-male court that handed down Roe had not yet even recognized that women were entitled to equal protection. Roe augured the development of that body of law. The court did recognize that women and their doctors had a right to privacy. The court simply counted the injuries of pregnancy, recognized competing theories of when life begins, and asserted, in view of all this, we do not agree that by adopting one theory of life, Texas may override the rights of the pregnant women that are at stake. I can make sense of Roe as inchoately beginning to recognize women as a different kind of legal subject than she had long been in the eyes of the law. But Dobbs seems to long for that earlier era, seeming to hold that earlier view of women, and so reads Roe with contempt. If the legal existence of woman is suspended during childbearing, if she's in coverture, then there are no rights of the pregnant woman that are at stake, and Roe was wrong. Dobbs' account of our law, past and present, makes sense as you recognize that Dobbs reasons from this familiar view of women that women exist for childbearing. Why else is the court indifferent to the cascade of harms that state action coercing pregnancy inflicted on women, past and present? I refer here now not only to the opinion's discussion of the 19th century campaign, but to its dicta on equal protection and to its holding on reliance. In co-authored work in my Dobbs Equal Protection amicus and 2 essays on abortion and equality I posted this year, I've made the following simple point. It's not doctrinal. I mean, I have made it doctrinally, but I'm not making it doctrinally now. In the 21st century, women's equal citizenship requires government to protect potential life in new ways. Carrie Franklin and I call this an anti-carceral presumption. In a gender egalitarian society, government efforts to protect potential life should look different than in a world in which the work is performed by a disfranchised caste. There are a multitude of ways that states can protect new life that are compatible with women's equal citizenship. To reduce abortion, states can assist those who are sexually active and wish to avoid becoming parents. To protect potential life, the state can assist those who are expecting children and will become parents if they could afford to do so. These are forms of state action that do not target and coerce women resisting motherhood. But remarkably, the states that rush to criminalize abortion in the wake of Dobbs are the states that are least likely to have pursued any of these other means of protecting potential life. The correlation is shocking. Shocking. Their policy is not only to employ criminal law means to protect unborn life, but to do so while denying the people coerced into giving birth the forms of social provision commonly offered in other states. There's no reason well, I'll just skip this. I'm just going to say this briefly. In the 19th century, it might have been acceptable, in the view of law and many Americans, to threaten to coerce women to compel them to become mothers by criminalizing abortion. But that anti-abortion regime stripped women of agency and subjected them to forms of coercion and control. My last 3 sentences. Incompatible with 21st century understandings of liberty and equality. Clearly, our court romances the idea of return. But since Dobbs, other decision makers in our constitutional order, many other decision makers are speaking out, invoking liberty and equality in the Constitution's name. The voters not only of California, Michigan, and Vermont, but yesterday, I think remarkably, the Supreme Court of South Carolina conducted this remarkable conversation about the meaning of liberty and equality. So I conclude my open here by saying that a new 21st century chapter of this conversation is just now starting.
Thank you very much to all of you. And I'd just like to give you each, I apologize for the cutoffs, I'd like to give you each 3 minutes or so just to comment on any points that have been raised by others that you have something to say about. So we can head down the line if
Okay, maybe that's easiest.
Yeah.
I'll just quickly say a few things in response to Professor Jackson's comments. Professor Jackson first said that the purpose of a constitution is to endure over time, and that there's a risk with originalism of a separation between the meaning of the Constitution and the views of those living today if you entrench what the Constitution means in 1868. And that could imperil the legitimacy of the Constitution if you have that real separation between what the people believe today and what the Constitution means. I would say a couple of things there. One is that one of the purposes of the Constitution surely is for it to endure over time, but also to entrench certain things as a hedge against future generations changing their minds about things in the heat of a political moment. So we don't actually care that a future generation might think that free speech is bad and that it should all be banned. We think that we should entrench the free speech right in the Constitution as a hedge against future generations disagreeing with us on that, because we think that we're right about that, that we should have a right to free speech. And to the extent that that creates a separation that imperils the legitimacy of the Constitution, it seems to me that's an unavoidable consequence of a system that creates a system of higher and ordinary lawmaking. So again, I just think that Professor Jackson's argument is inconsistent with that separation of higher and ordinary lawmaking that our Constitution assumes, and that's really the whole basis for judicial review. Last and second very quick point is that Professor Jackson says, well, why, if the whole point of a constitutional amendment is to change the existing law, why would you assume that the meaning of that constitutional provision reflects existing law about abortion or something else at the time? And I would just say she's right that, of course, the meaning that a constitutional amendment is meant to change existing law, but it changes it in some ways and leaves it in place in others. So, for example, prior to the 14th Amendment, there were no privileges or immunities of citizens of the United States that were enforceable against the states. That's a change in existing law. But what those privileges or immunities were was a pre-existing concept. That wasn't a change in existing law. That was trying to take an existing concept and then change the law to apply it against the states. And so I think it just begs the question to say, well, we're trying to change existing law. Well, it depends on what law we're trying to change. And in the case of abortion, the argument is that, yes, the 14th Amendment is designed to change existing law, but what was it not meant to change? It was not meant to include this right to abortion as part of privileges or immunities, or if you have an understanding of substantive due process as consistent with originalism, then fine. And so I think there just has to be a more fine-grained inquiry when you're trying to figure out what changed and what didn't when this particular change in our law occurred with a constitutional amendment.
Thank you. Professor Jackson.
Thank you. In response to Joel, I want to say I think approaches to Constitution that put things in two boxes usually miss a lot of important stuff in the middle. The opposition, Joel just suggested, between entrenchment and it's all up for grabs, I want to say is a false one. The First Amendment has clear text about freedom of speech. Getting rid of it would be contrary to that text. The text of liberty and equal protection are much more open-textured. They call on us to interpret. Okay, so I think that's my response there. And so likewise in Joel's opening talk, the opposition between you're either bound by what they thought in 1868 or by what we think today. And I want to say, no. There are a lot more boxes than that. And that having the Constitution's interpretation understood as going across generations, including original understandings, but then precedents as they accumulate and understandings over time. On Sherif's comments, let's see, on the way that, on Justice Kagan's comment, I think we all feel there's something to that. You don't want to have a change that's just attributed to a single change in membership, but he's absolutely right that the change in membership is the way in which we kind of keep the court accountable to our democratic republic. But it's a very flawed system. We have the Senate playing a major role, and the Senate is a counter-majoritarian institution a lot of the time, if you look at the distribution of the population as it is reflected in the Senate. So this current Supreme Court has 1/3 of its appointees from a one-term president who lost the popular vote. And so this has to mitigate the argument that you were making there. And as to the ordinary burdens of keeping your child safe, I kind of thought, oh, what an elegant argument, elevating it to that level. But let me tell you, I don't think being pregnant is an ordinary burden of bringing a child up. Even in Germany, where the German constitutional law is, there is a duty on the part of the state, the government, to protect unborn life starting 14 days after implantation. That's German constitutional law. Even under German constitutional law, the court has said there are some sacrifices that cannot be exacted from a pregnant woman. If her life or health are at stake, you cannot prohibit abortion. If her pregnancy results from a criminal act against her, you cannot prohibit abortion because that would be an inexactable sacrifice. I can talk more about it, but I think it is a mistake to take pregnancy in that direction. Can I say one more thing about the rule of law? Sure. Okay, so one of the questions for the panel was Dobbs and the rule of law. And I want to say I am worried. But I'm worried not just because of Dobbs. So in Dobbs, I'm worried that the tone of, I think, really disrespect for prior courts from Roe through Whole Women's Health in 2016 was concerning. So not just the departure from stare decisis, but the scorn and disdain that came through that opinion, coupled with the increasing practice of granting cert before judgment so that the court doesn't have the benefit of Court of Appeals consideration, of actions taken without full briefing on the shadow docket, and the Supreme Court's deciding questions, as it did in Dobbs, broader than those on which cert was granted. This collection of acts manifest a kind of disdain for the lower courts and for the ordinary processes of adversarial litigation. And I worry that the Supreme Court cannot long sustain its own legitimacy or that of our constitutional law by tearing down the overall federal judicial system. That's what I want to say.
Thank you.
Great. So I think 5 points in 3 minutes, but they will be, some of them will be short. One of them is on the debate between Professor Aaron. I'm going to direct you to a debate between Professor Aaron Tang, talking about what exactly was the state of these state regulations in 1868 on the one hand, and John Finnis and Robbie George on the other. They have a piece up on SSRN that's responding to Tang's arguments, and rather than editorialize on the way I think well, I will editorialize for a moment. I'll just tell you, I think that on every single one of the, I was completely open to Professor Tang's arguments, but I think on every single one of the states at issue, without exception, the argument doesn't hold up to scrutiny. But again, I just direct you to those two pieces. On the question about the ordinary burden, so I think the way that I agree with you that so at least some forms of pregnancy will involve extraordinary burdens. And I actually think this explains why some of the exceptions that are most prevalent exist. The question of what the ordinary burdens are will be pegged, indexed to every given stage. So the burdens for a newborn are not the burdens for an 17-year-old, and likewise for the fetus. But the idea is if, in general, parents have a duty to make sure that the kid gets from here to there, then at each given stage, if the burdens are ordinary, there will be an enforceable duty to carry them. And then the question is, does this count as a kid? And I think that even if you thought that the fetus was a full-blown person, there would be some burdens that you would not expect, for the same reasons that you would not expect them of you or me, involving people walking around, right? So self-defense and so on, and there are close analogs between that and procedures needed to save the mother's life or serious health. The third point is on quickening. So I think that there's a question in the literature and in the opinions about whether there was a right to abortion before quickening. I think even at common law, I think even though it wasn't itself a crime at common law before quickening, it was subject to very serious legal burdens that are inconsistent with the idea that it was a right. So it was treated as a predicate for felony murder, which only felonies are otherwise. It was subject to heavy regulations. If you advertised even pre-quickening abortions, that was itself a crime. If you were in a building that provided them, that building was subject to summary closure as a disorderly house because what it was providing was to no lawful intent, as some of the state court judges put it. So it wasn't a crime, but it was still unlawful and burdened. On the question of scope, let's zoom out. 1868 is too narrow and too specific and too retrograde. We need to zoom out, as the dissent says at one point, to the full sweep of our history. And then the majority says we've done exactly that. Yeah, in 1868, 3/4 of the states had banned abortion in all forms except for procedures needed to save the mother's life. But as late as 1960, all but 4 of the states, as Roe itself said, banned all abortions in any form except to save the mother's life. So no matter how far you zoom out, you're not going to get there. And then the last point, and this is the last sentence, is that Riva is rightly pointing us to the fact that there's not just a kind of abstract question of whether we have to posit a discounting of fetal moral worth for these states. We can look at the sociological facts, see what people said and did. And on the 21st century aspect of that, and she's heard me make this point before, I think that it's telling that the gap in public opinion on abortion between the sexes, between the genders, between men and women, is smaller than it is on almost any other issue. And that's some kind of point against the hypothesis that the only way to be in favor of abortion regulations in the 21st century is to discount women's interests.
Professor Siegel.
So first, okay, so first, no, I wanted, all right. First, I want to say that on the question of the replacement of court personnel and law changing, in my work on democratic constitutionalism, I have celebrated the fact that the court is actually connected to and responsive to the body politic. I don't see that as somehow or other a deformity. It's actually hardwired into our Constitution, but it's also mediated by constitutional norms, and those constitutional norms command our justices to treat the Constitution as law. And I'm not going to take my few minutes to go on about stare decisis here, but the way in which past law changed here was, as even Chief Justice Robert was concerned about, extremely pressuring the very idea of a court, given how much public dissensus there was about the form of those confirmations, the 3 confirmations, not just that there were 3 confirmations during the Trump presidency, but what happened as the 3 justices were confirmed. And I'm not going to go through the details of Merrick Garland and Justice Barrett. I'm just putting that out there. And when you put all that together and you say that the court has to command the confidence of the nation, that just says that a prudential court that's concerned about it retaining the confidence of the nation rather than a sector of the nation might be wise to take that into account. That's point 1. Point number 2, on the quickening point. We're not talking the legal formalist question whether there was a right to abortion in the early 19th century. Women didn't have rights. That was my point. The question was whether the common law actually criminalized, prohibited abortion in that time period. The answer is no. So deep, I mean, not until quickening. That is to say, midway through or developmentally partway through the pregnancy. And so, the importance of that is to say that that fundamental understanding of pregnancy shaped the way in which legal actors in the system responded for a very long time, even well after the campaign began. And that's Tang's point, and it's worth looking at the last section of the Stanford article. I sort of thought maybe the draft leaked and they never got a chance to really check all of the statutes. I don't know, but it's really worth looking at the end of Tang's forthcoming Stanford article. I do know on the ground that the reason that the bans were being pushed is because the doctors who are advocating them understood that the public believed in the quickening framework. From a public understanding of the 14th Amendment perspective, the public did not think life began at conception. That's why the doctors were arguing for a change of the law. They were engaged in advocating social control statutes. Okay, third point. I think that when you talk about whether there's gender in abortion bans, you move to the realm of formalism, Sherif. You're not talking constitutional law. We could get into a question of how, whether Godaldig or whether Virginia applies. We're not in that conversation now, but neither are you. And when you say you have to find a comparator, why do I have to find a comparator? I can understand a social practice when I look at it, and I think many other people see it as well. So it's a longer conversation than in a 3-minute exchange that we could have, but saying that I have to look for a comparator is telling me I don't have to read what I can understand from the very history I just recounted to you. So it's another way of seeing what I see. What is odd here, and I want to move to this as my last point, and it's really, I think, a really crucial point, and I'd like to end my comments here. I consider myself to be speaking on behalf of life and the care ethic, and I always have. I'm speaking on behalf of motherhood and speaking in support of motherhood, and I feel I actually just worked, you know this, I just worked to get passed across the aisle the Pregnant Worker Fairness Act, and I have long been working to change the condition in which mothers and families raise children. And I said what I said about the facts on the ground in the jurisdictions that are adopting abortion bans in grief. I think as a nation we can do better, and we should do better. And if we did better, this question would be less central and less salient. And I think we need less criminal law punishment and more collective support. And I don't know if this resonates in this room, but it's the Christian thing to do. So what I'm saying, and I want to be heard as saying, is that I believe in supporting those who are trying to raise families, and I believe that if we believe in giving family values real meaning, we'd be doing that with our law. And that's what I'm calling for, not just punishment. That's what I was saying. So I want to stop these remarks there. That's my larger context.
Thank you. So now we will have a few minutes, less than planned before, but a few minutes of just sort of conversation on the panel before we get to your questions. And I just want to throw 2 questions out for people to think about. They don't have to address this, but these are things I think would be useful to think about. The first is a contrast between originalism as fetter or originalism as license. So it might be that sometimes the role of originalism is telling you, you, current majority, cannot do what you wish, because something in the Constitution prevents you. Or it could be you, current majority, can do whatever you want because nothing in the Constitution prevents you. So something like, if it were the case that sedition acts are consistent with the First Amendment, that would just be saying current majorities, if you want to pass a sedition law, go ahead. Does that contrast, and given that Dobbs is saying essentially that state legislatures, which are not necessarily, the voice of the people, but that state legislatures have more ability to regulate, or that Congress might have more ability to regulate than it did before, does that change how we should understand the role of past constraints with respect to the Dobbs opinion? And then the second thing I wanted to ask is is Glucksberg back? If you're a lower court judge today and you have a fundamental rights case in front of you and you're looking at Dobbs, do you now apply Glucksberg? Was that what you were supposed to be doing beforehand? One of the interesting features of Dobbs, and indeed of the Dobbs dissent, is that neither the majority nor the dissent talked about the passages in Obergefell which were throwing cold water on Glucksberg, which were saying that, well, it hasn't really been applied in cases involving intimacy to the same extent. It didn't really say why, but it just said, in general, we haven't been doing that. Now seems like that is what we're doing. So is that now the correct way? If we're teaching kids about fundamental rights jurisprudence, is that the right way to think about it based on current doctrine, or is there another way that lower courts and that attorneys and that academics generally should be thinking about current doctrine on fundamental rights?
Can I just say a word on the second question? So
Sure.
I think...
Yeah, I'll let you guys go for about 10 minutes, and then I'll invite folks up for questions.
I think it does attempt to make Glucksberg the all-purpose standard for substantive due process. And it says, if you have a pang of conscience about substantive due process, well, in a footnote, we're going to tell you privileges or immunities would go by the same test anyway, so relax. And that's an across-the-board thing. But there's a wrinkle, which comes in the attempt to distinguish Obergefell and the other cases. And there I read the court to be saying, it's a very compressed argument, but I read it to be saying basically, we will grant you for argument's sake that even if an activity is not itself the subject of a deeply rooted right, it could be protected if it's integral to a broader right that is deeply rooted. And we'll grant you for argument's sake that privacy or autonomy, the key terms that Roe and Casey used, are themselves broad, deeply rooted rights. And we'll grant you that all of the other cases you're asking about are integral to one of those. We just think abortion's different because it's not just about privacy or autonomy, the acting person, the claimant herself. It's also about impact on third parties, or at least arguably so, and that takes it out of the realm of the kind of Mill principle. So I think that that's the most unwritten rights friendly reading of the state that it leaves us in.
Can I just ask a question, and I mean this genuinely as a question. Why didn't the court just write that opinion? In other words, if it didn't mean to cripple these other rights, maybe cripple without overruling, why did it write such a broad opinion?
Well, I'm quoting what I think is from the opinion itself. So it goes through it dumps on the history in Roe, and then it says some amici and the parties and the...
But let me restate my question. Given, so this reading of this test is coming from the dissenters in Obergefell, and it's even changing the original version of the test because the original version of the test included abortion within its reach. When Glucksberg was handed down in '97, the court never acknowledges this in Dobbs. Glucksberg, as written by Rehnquist in '97, includes abortion as a protected right. Poof, gone. So nothing is explained in the opinion. It retrieves this from the dissent in Dobbs, doesn't explain the relationship, and just treats it as governing law. But you're saying we're supposed to treat Dobbs as somehow they're protected by this opinion. It could have just written the opinion that says abortion is different because it implicates protected life, and then we wouldn't have had something that affected potentially Griswold and Laurence and Obergefell. That's my question.
Okay, so I don't read it to be affirmatively embracing Griswold and the others. I think it's saying here's a distinction between all of the other interests that are cited and abortion. And that's why the ratio decidendi we're relying on today doesn't impugn those other things, but we're not saying that we would all, 5 of us, re-embrace them.
So I think the colloquy we've just heard suggests that if you're a lower court judge, you can, in good faith, make different choices about what to follow in resolving some of these other privacy, substantive due process issues. So we will have to wait. I would like to take up your first question, feder or license, which is, I think, a wonderful question. Rubenfeld had an argument many years ago that if something was just left alone, you couldn't see it as a commitment. I'm not sure what I think about that, but that's what it made me think about. The way I think about the very good question Professor Sachs raised is, at a very general level, democracy is an important value. Constitutions are supposed to promote opportunities for democratic majorities, and in a federal system at both the state level and the national level, to make decisions about self-governance. At the same time, constitutions mark out some areas where we say, no, we're not going to let majorities burden people in this way. And so how do you figure it out? And so I think you're back into that very basic question under the Liberty Clause of the Constitution, and for me also equal protection. I know the court said not. One thought I've had in disagreement with John Hart-Ely, great disagreement, is this. I don't think many people, many young women, imagine themselves being pregnant when they don't want to. I think that's going to change now in post-Dobbs, but I think you don't think you're going to be raped. And so even though you're a full voting member, you may not be thinking about, oh my gosh, what do I do? If you get pregnant, you don't think, I may have a medical emergency in the 4th month. Do I want to be in a hospital where the doctor is afraid to perform an abortion on me? This, in Ireland in 2012, a married dentist, pregnant, wanted the kid, got very sick. And after 6 days in a hospital with sepsis, where the doctors were afraid to perform the abortion because there was no law that let them know if it would be permissible, she dies. But my point is the circumstances that give rise to a woman's decision that she needs to terminate a pregnancy may be sufficiently unforeseeable that I am not sure we can rely on the ordinary political processes to fully take account of those. Getting back to Sherif and my disagreement about ordinary burdens, I think Justice Breyer, in one of his opinions, had the most recent data I'd seen, which is comparing going to term with pregnancy with having an abortion. 14 times greater risk of dying continuing the pregnancy to the end. And if you're living in a poor minority neighborhood, the risks are much higher. So I'm not sure being pregnant can be treated as anything other than sui generis with respect to the intensity of the burdens that it imposes on one's body when one is pregnant.
I suppose I'll just quickly add to the discussion on Glucksberg to say I do think that the best reading of current doctrine in light of Dobbs is that Glucksberg is the governing test for substantive due process unenumerated rights moving forward. Dobbs, the majority opinion, presents the Glucksberg framework as the test for figuring out whether there is an unenumerated right under substantive due process. Now, the only, I think, maybe not the only, but the primary reason for any doubt on that point is the point that Professor Sachs raised, which is that in Obergefell, the majority opinion expressly distinguishes Glucksberg, refuses to apply its framework, and then in Dobbs, the Supreme Court applies Glucksberg without acknowledging that in Obergefell the court had not done so. And the dissent does point that out. The dissent points out that the majority opinion refuses to deal with Obergefell and what it said about Glucksberg. I think that is probably the strongest legal point the dissent makes in the entire dissent, is just to say, like, well, if the whole thing is about this legal framework, then you need to explain how this is reconcilable with Obergefell, where we said we weren't going to use that legal framework. I think that the best response to that is just to say, well, Glucksberg purported to be, whether you think this is accurate or not as a statement of our law in the late 90s, Glucksberg at least purported to be distilling a test from the substantive due process cases. Obergefell, in distinguishing Glucksberg, does so on grounds that I think are extremely difficult to defend, because it's just such a thin kind of make-weight distinction of saying, like, well, it's just about, well, Glucksberg was about end-of-life cases. These cases about privacy and autonomy are different, so they get a different test. Why? What would be the rationale for having a different test when you have the exact same constitutional provision answering the same question about whether there's an unenumerated right here? So it seems to me that actually, where we have a deviation in the jurisprudence, it is Obergefell as a deviation from the law that had been in place before Obergefell, which was that Glucksberg was the governing test, and Dobbs is simply reasserting that the test that was in place before Obergefell is the governing test, which is Glucksberg. But I agree entirely with the criticism of the majority for not saying something like that, for not just expressly dealing with Obergefell's distinguishing of Glucksberg, because I do think it's going to lead to some confusion in in the lower courts about, well, then what is the governing test here?
So Professor Siegel, very briefly, and then we'll call folks up for questions.
So I want to say that in reading the opinion, I found it bizarre to have all of this attention devoted to Roe's overruling and then to just see those parts of Obergefell. I don't know if we want to use the word overruled, but basically effectively overruled sub silentio. There's just literally nothing. And also, there's kind of like Glucksberg and its twin. Glucksberg actually embraces Casey, and it's just erased. And its test had to have included a form of reasoning that provided for Casey, and it's offed without any mention. So I don't find that reasoning. That's just power. But the thing I wanted to say, and it goes much more to your last point about what one is the real test, and this is an historical point about our law. There was a multi-generational, like over the decades, great conversation or argument between Justice Kennedy and Justice Scalia about this question that ran from Casey to Laurence to Obergefell across a set of cases about the character of the Constitution and its requirements in this area. And I raise it because it's important. The court is now taking a turn with its new membership, definitively repudiating an understanding of our liberty that Justice Kennedy espoused for the 30 years that he was on the bench. But it was a dynamic, an evolving, and intergenerational learning understanding of the scope of constitutional protected liberties that was quite self-consciously debated, and Justice Scalia's view lost over and over and over again. It's not there was a real Glucksberg view and then it just got put back in place. It's that in these cases, Justice Scalia was in the dissent, furiously so, robustly and energetically and powerfully so, but nonetheless in the dissent for decades. And that body of law has now been spurned. That's what's happening here. And I just think it's important to recognize the turn that we're at. It's a different picture of what it means to have a constitution, and it's an alternative picture relative to the story about originalism and how groups that have been outside the constitutional community can be invited to join it or be a member of it. And that's how it is that we got Casey, Laurence, and Obergefell, and that's why this decision is in such tension with them.
Thank you. I think we'll invite folks up to the microphone now. As they're coming up, I will abuse the privilege of moderation to insert my own comment, which is that I think that one sort of underlying tension in Dobbs, it's not sort of explicitly discussed, but I think is very clear under the surface, precisely is the question of what do we make of all of these losses? Sort of, does that actually change the constitutional law, or are all these decisions merely evidence of laws and not laws themselves? I think if you take the latter view, then it seems more plausible that, well, they might be bad evidence of law, and it might cause one to be less attached to them. Whereas if you think that the substance of constitutional law is expressed in what happened over the course of that 30-year debate, then one would think of oneself as sort of really overstepping those potential bonds. So thank you.
Thank you. Amazing panel. I have 2 comments and 3 questions.
And Professor Updike-Toller,
I'll cut that down.
I was going to say, if everyone could identify themselves after Professor Updike-Toller.
Sure. Laurence Updike-Toller. I'm at Northern Illinois University. I also have an appointment or an affiliation with Yale that allows me to use the library and allows me to see occasionally people like Professor Siegel. Thank you for your work on behalf of families raising children. I'd like to talk to you offline about some of that work. And I did want to make one point for Professor Girgis, that having a child always imposes an extreme burden on the mother. As the mother of 3 children, I have 3 burdens that I signed up for. And that's often a part of the calculus with regards to this debate that we don't talk about consent, that I'll leave to another time. My 3 questions are actually for Professor Jackson. First, you mentioned Nick Barber of Oxford in setting up your remarks and how constitutionalism should contribute to changing dynamics in society. But from what I understand and know of Professor Barber's work, whom I studied with a bit at Oxford, his main premise is to say you cannot have a written constitution. So what does that do to that argument of change versus unwrittenness? Secondly, you also mentioned Professor Strauss's concept of a living constitution, and his point that enduring constitutions are general, but that flies in the face of the very compelling work of the Comparative Constitutions Project and their quantitative data that show that it's actually specific constitutions that endure. So how do you deal with that? And you also mentioned that Dobbs provides no framework for dealing with stare decisis. And if I have read it a couple of times, if I understood your remark clearly, that Alito actually provides a rubric for when we look at stare decisis and when it should govern and when it should not. So with that, I will leave it. Thank you.
Steve, do I respond now?
If you like.
Okay, I didn't know what the custom was.
Sure.
Okay. Thank you so much for your comments. Your name was Maureen?
Laurence.
Laurence, I'm sorry. So on Nick Barber, so one of his major arguments, and he's involved in many debates in the UK, is about why, for the UK, it's actually a good idea to not try and put everything in writing. He's got wonderful arguments about how if constitutions are supposed to help you have a well-ordered, civilized society with lots of people who think differently, not deciding things too firmly is a good idea. So he's not working in the realm of our written constitutions. The idea I took from him, however, which I think does generalize, is that he asks, what is the purpose of having a state? Why, if you're a little society or a little family, you don't need to be a state. But if you get large agglomerations of people living together, you actually need to have a state. And what's the purpose of a state and the purpose of its constitution is to promote people's welfare. And I think he argues this as a generic characteristic of constitutions, and it certainly fits with our Constitution, whose preamble refers to the general welfare and whose opening clause on Congress powers also does so. All right, that's on Nick. On David Strauss and the evidence from the comparative project about, so I think what the evidence shows is not that Strauss is wrong, that there's a benefit in having some provisions that are general and some that are specific. What I think it shows is that having more topics covered in more specificity in constitutions is associated with their lasting longer. And the articles that I'm familiar with, which come out of Tom Ginsburg and Zachary Elkins' work, suggest that one of the reasons for that is those longer, more detailed constitutions, which also have provisions, for example, protecting liberty or equality, but that the length and specificity represent high degrees of participation by different groups in society in making the Constitution, which they speculate causes people to become invested in their success, which I think resonates with my argument in our very difficult to amend setting for why having engagement with different generations through constitutional adjudication is important for the legitimacy of our Constitution. You know, India is the longest, or for many years has been the longest constitution in the world, has many very specific provisions, also has some very general provisions, and it has been amended, I looked this up last night, I think it's 104 times since 1950. Our Constitution, depending on who you ask, 27, 28, 26, something around there, since 1789. And Alito's structure, you know, he does go through I found it seemed to me that what his real argument was, Roe was just wrong. And there are many decisions about which justices today might feel that way. I didn't find his other arguments entirely persuasive. So, and I worry about a stare decisis approach that just said, with respect to a decision that had been repeatedly, not in its trimester framework, but repeatedly reaffirmed, to just be disavowed was troubling. Okay.
Thank you.
Thank you.
I'm Abner Green from Fordham. Nice to see you all. It was a great discussion. I have a question, I guess, more for Joel and Sherif, but I'd be happy to hear Vicki and Riva on it, which is a little more about the stare decisis discussion in Dobbs, and particularly about the reliance discussion. If you, the two of you, and then maybe four of you, could talk about Alito's treatment of reliance, in particular, what counts as a tangible or intangible reliance interest.
Yeah, I'll say something, I hope brief. So Vic Amar had a piece, I think, in Justia, I don't know how to say the name of that outlet, Justia, that talked about this, and he said, look, I think he thought that reliance for purposes of stare decisis is detrimental reliance, which means, are you worse off if we take away the precedent than you would have been if the precedent had never existed? So it's not tangible, intangible so much as detrimental, non-detrimental. I think that lines up with what Justice Alito is saying, and he cites that passage where Casey is at least entertaining that argument before going on to say why it's not sufficient. Casey says reproductive planning could take immediate account of any change in abortion regulations. I think that's the idea about detrimental reliance. So I see the distinction as, do you take it that way, or can there be a broader sense in which the existence of the precedent and the way that society and half of society comes to think of themselves in light of the existence of the precedent gets weight on its own?
I don't think I have much to add to that. I'll just say that I do think that the way in which Casey conceived of reliance interest and the dissent in Dobbs conceived of reliance interest is so expansive that it really does make that criterion of stare decisis somewhat vacuous. If it's that expansive, it's very difficult to know how you're distinguishing between reliance interest as some sort of objective legal criterion for assessing whether to overrule a precedent, and it just coming down to the judge's own personal view about whether they like this precedent or not. You can if you conceive reliance interest in such an expansive way, I think it very much imperils kind of the stability of how and the rule of law values that are attached to stare decisis.
Yes, thank you.
I'm just going to say something terse here, which is you may not like what Casey said, but Casey said what it said. And not only did Casey say what it said, but what Casey said was treated with extreme significance by many people and repeated endlessly all over the place. And it was dismissed, or depending on how you look at it, as if it weren't there. That is beyond the court to take account of. It doesn't matter, like guns or religious liberties or just basically contracts or business stuff or anything judges could spend their time thinking about, but this what you were saying, Vicki, about what happens to persons when they're pregnant, or that is not within the capacity of it's actually even many of the opponents of Roe spend enormous amounts of time on lengthy amicus briefs. All of it was just whoosh, gone in like a couple sentences. And it's consistent with the 2 paragraphs on the equal protection point, which in any event wasn't in the case, but it just was part of the tenor of the opinion that perplexingly managed to signal a kind of disrespect when it wasn't necessary. If it had been sort of you're equal persons and still equal citizens, but because of concern about unborn life, we regret that, that would sound different than that your concerns don't even warrant notice, which is the way it came across.
Hi, I'm India Tusi. I'm a professor of law at Indiana Maurer School of Law and a senior scientist at the Kinsey Institute for Sex Research. I really enjoyed the panel, and my question is directed toward Professor Girgis. I have one question, and then I'm going to explain why I'm asking this question. And so I wonder whether your analysis takes the conditions of pregnancy seriously enough, right? And so your argument was focused mostly on the Equal Protection Clause argument that had been made. And my understanding of what you said today was that a lot of the arguments come down to this question around fetal life. So let's assume that's the case. We take this question of fetal life, and let's assume that a fetal life is a life. But even if we do that, the life comes into fruition through the extreme conditions of pregnancy. And so Professor Jackson elaborated on some of that, but even if we take the mundane aspects of pregnancy, which aren't often discussed in these conversations, right? The fact that most or all women, you're going to be stretched beyond physically during the course of a pregnancy. Most people are going to have diastasis recti, which is the literal separation of your stomach during the course of pregnancy. And after pregnancy, a significant number of people will experience anxiety, depression, your body becomes unrecognizable, and you actually have a disabled body. So I think the comparison to homicide that people often made is inelegant. So maybe a better comparison might be to laws that criminalize different conduct people engage in during pregnancy. Maybe that's better. Or maybe it would be a homicide that's done under duress. So I think a better question might be, what can a person do to another life, assuming, arguendo, that fetal life is a life, in order to prevent their physical disability, right? And so I think that's a different question. I don't think that question, I haven't heard it really engaged with, and I think that question actually takes the condition of pregnancy very seriously, because what we're dealing with is not 2 lives that already exist and someone committing a harm to that life that exists, is that we're asking someone to physically disable their body in order for another life to come into fruition. And I think that's a slightly different question. So I wonder how you would respond to that, whether you think your analysis would actually address that. And I think that also makes the question around parental obligation different, because we don't ask parents, you must physically disable yourself in order to feed your child, right? So let's say we know a parent might be suffering from depression as a result of them feeding their child, which may be the case of a pregnancy, right? And so I think it's a really different question, and I wonder whether how you would respond to that.
Sure, thank you. So a couple of thoughts. One is that, I think I mentioned this before, but I should reiterate it. When I talk about this norm, what if the idea that pregnancies ought to be carried to term just depends on these 2 other ideas, that the baby is a person and that we have an obligation to bear the ordinary burdens of keeping our kids alive? When I was saying that, and when I talked earlier about indexing ordinariness to each stage, I was trying to acknowledge what I take to be one of the points that you're making, and which is obviously right, which is that the burdens of pregnancy are not the same, are much graver than the burdens at other stages. So, but I think you're also right to think that, look, my point was a kind of analytic one, that what is the argument depending on? Is the argument depending only on the claim that we need to avoid violations of equal protection, or is it depending also on the claim that the fetal life counts significantly less? So I think the thought experiments you were relying on are exactly the right ones to go to. To bracket out the second premise, we have to assume a case where everybody assumes that it's a person whose life whose life is at stake, and then we ask, what burdens do we expect of other people, right? And I think you are right that, so for self-defense law, for example, in most jurisdictions, the common law rule, and I think still today, the rule, is that you have a right to lethal self-defense, even though this other person is a person, if you are preventing for either death to yourself or serious bodily injury to yourself. Right, so if we're assuming, for argument's sake, for a moment, that the states are allowed to treat, that the Constitution itself doesn't prevent them from seeing fetal life as unborn human life, then what they would be required, and if we assume that self-defense is analogous to abortion in other respects, lethal self-defense, then what is required is that if the pregnancy is going to cause either death or serious bodily injury, the woman has a right to that procedure. And a lot of the pro-life, so every one of the states and territories in our whole existence as a nation, and in the Anglo-American law, the common law that Dobbs cites, every one of them has made an exception, has permitted, has authorized procedures needed to save the mother's life. And I think the majority, the overwhelming majority of states today, including very pro-life states, also make an exception for procedures needed to prevent a serious and substantial risk of serious bodily injury or damage to a major bodily function. And so then the question is, now, would I be allowed to cause someone else's death in pursuit of something more than prevention of death or serious bodily injury to myself? And if the answer to that is no, then in order to support a right to abortion access, you have to say, actually, the fetus does count for less. That was the main point. And the final point I'll make on this is that notice that none of these arguments address, so the arguments from bodily autonomy would not justify abortions where the goal is not to detach, to evict the fetus from the body, but to cause the fetus's death. So if the goal of an abortion in a given case is to avoid the dilemma of the wrenching experience of giving up the child for adoption, and on the other hand, the experience of the burdens of parenthood once the kid is alive, or once the kid is out of the womb, once the prenatal life is postnatal. If those are the twin goals, then the means is not to remove the child from the body. The means is to cause the child's death. And so then these arguments about sort of incidental harm to bodily injury or life of a person, and people are allowed to prevent that to themselves by causing someone else's death, don't actually apply anymore. Now we're just in the territory of when is it permissible to seek the death of an innocent person as a means to further ends, and I think the law outside of the kinds of contexts we're talking about doesn't allow that. So that's why I think, look, I haven't argued against the equal protection argument full bore. I've just said it depends on a suppressed premise that isn't acknowledged.
Can I say?
Go ahead, Reva.
So I just want to argue against trying to resolve this in a way that analogizes it to something that it's not. When men become fathers and when women become mothers, their circumstances in the world diverge. They diverge physiologically and they diverge socially. And I think if we just use a class of become parents, we miss how profoundly those circumstances diverge. It doesn't follow that when men become fathers that things happen like they can't go into politics and they lose their jobs and they get things like that. That just doesn't follow, and it doesn't follow from the physiology of pregnancy either. So I'm concerned about abstracting from context. It doesn't describe where the work of gestating and where the work of upbringing and all of that is landing. So that's number one. And number two, I'm also concerned with arguments that say, let's just assume it's a born person, because I live in a society that has never, no matter what words it's used to describe the genuine moral concerns that people have about abortion, has never regulated abortion as murder. That is to say, at common law, infanticide was the crime that involved murder, and there was a born alive rule. So these two things are not the same thing. In the field codes, abortion is grouped as a crime against the person and against public decency and good morals, and it's with rapes, child abandonment, bigamy, indecent exposure, and lotteries. So it's not seen as it's a wrong, but it's not that kind of a wrong. And same thing, model penal code, it's a crime against the family. So it's a wrong, it's grave, but it's not the same thing. Also, whatever the laws said, they weren't enforced against women. So that is to say, against the pregnant person who had and participated in the abortion. So we have to understand that society could be very serious about something and not treat it as the same as something else. And in that South Carolina opinion that I read last night, and I actually also read Ed Whelan complaining about it this morning. In that South Carolina opinion,
I hadn't read Ed Whelan. You're a better reader of conservatives than I am.
In that South Carolina opinion, the third judge said, well, look, the state had the chance to adopt a personhood rule, but it rejected the personhood rule, so the state actually isn't committed to that view, and it has a different view of the wrongs of abortion, and therefore, we can't reason from that premise, you know? So I'm just saying we should be clear about where we are. Something could be a grave moral wrong in the people's eyes without being the same as. And so I just don't want to mix up the two categories. The gender disappears when you start treating X as Y.
Could I just one sentence note of agreement with that, just to take the opportunity? So both with the questioner and with you, I agree that, as I've said, pregnancy is sui generis, that's on the table. And I think that your reference to duress and other analogies actually, I think, explains why a lot of the states with all jurisdictions have always treated abortion different from other forms of causing the death of human life or something like it. And that's a kind of concession to that. It doesn't in itself entail that the fetus counts for less any more than all the other gradations and distinctions that homicide law makes. Entail that, you know, when the penalty is less, the person counts for less.
And to Professor Jackson for a very brief remark.
I was just going to introduce additional boxes consistent with my earlier statement that dividing the world into two things, either fetus is a person or it's not. In Colombia, which is a predominantly Catholic country in Latin America with a very interesting and good constitutional court, the court recognized a general constitutional obligation on the part of the government to protect life, including fetal life, but then said, I'm quoting from a translation from one of the justices, even though the legal system protects the fetus, it does not grant it the same level or degree of protection as it grants to a human person. In Germany, which I mentioned to you earlier, obligation to protect the fetus from 14 days after implantation, the court says this is an objective duty of the government, but it does not correlate with a subjective right attached to the fetus. So that there's a broader range of ways that good legal systems around the world have approached this set of questions.
So thank you. Unfortunately, we are 5 minutes after time, but I'm sure that the panelists would be willing to answer questions that folks have, with apologies to those unable to ask them. Thank you very much for coming, and thank you to our panelists.